Is the Ripple lawsuit holding back XRP? Does Sarah Netburn want the case to end quickly? What is the minor win that the Security and Exchange Commission has scored? Stay tuned till the end of the video to find out. Welcome back XRP Army. Let's grow the XRP Lab community by pressing the like button and subscribing to this channel to stay updated at all times. When stablecoins are excluded, XRP is the fourth most valuable cryptocurrency by market capitalization, trailing only Bitcoin, Ethereum, and Binance Coin. XRP is the digital asset that is indirectly on trial in the ongoing Security and Exchange Commission vs. Ripple lawsuit. The coin used to be ranked higher, only a few places below Bitcoin, but things have changed dramatically since then. However, XRP will be here, and that sort of framework will continue to develop enormously, whilst the old system, including that on which the Security and Exchange Commission has built its whole existence, will continue to be swamped by it. Affecting the entire blockchain industry, the XRP lawsuit prevents the blockchain giant from reaching its full potential. Once the court case is concluded, the company flagship products, RippleNet and on-demand liquidity, are expected to see a significant increase in onboarding. In the case of its central bank digital asset solution, the same holds true. Furthermore, the long-awaited plan to go public through an initial public offering will remain a mirage until a settlement or a court ruling clears the way. Because the price of XRP is tied to the adoption of the Ripple network, it is expected to see better days in the near future, just like Ripple. Because blockchain-based protocols such as Ripple provide the financial world with so much flexibility, it is highly unlikely that any institutional partner will be concerned about this matter once it has been concluded and a settlement has been reached. In fact, the majority of institutional partners who have begun to use tokenized methods such as XRP are very much on board with the modern, digital economy, and they are likely to believe that XRP will be here and that type of framework will continue to grow exponentially, whereas the traditional system, including that on which the Security and Exchange Commission has built its entire existence, will continue to be overshadowed by the digital economy. It is just a matter of development and advancement. Hence, market demand and infrastructure development are expected to continue in the foreseeable future. Once it is over and out of the way, it will be a question of moving forward and upwards from there. Do you think the Ripple lawsuit is holding back XRP? Share your thoughts in the comments. Also, in the court, the Security and Exchange Commission and Ripple have been directed to reach an agreement on the briefing timetable for summary judgment motions by the Southern District Court of New York. Magistrate Sarah Netburn said, "The parties are instructed to meet and confer in order to establish a timeline for briefing summary judgment motions. Following the Security and Exchange Commission submission, the parties must submit a jointly proposed timetable for the court approval no later than 1 week following the Security and Exchange Commission submission." As revealed in a recent petition filed by the Security and Exchange Commission, Ripple requested a summary judgment timetable that would have opening papers and relevant filings due by the mid of May. To no one's surprise, the Security and Exchange Commission wants to schedule the summary judgment hearing at a later date. Because a summary judgment schedule is premature, in the opinion of the Security and Exchange Commission, because individual defendants have not yet answered the complaint or raised affirmative defenses. Accordingly, the Security and Exchange Commission requests that the court direct the parties to meet and confer regarding a summary judgment schedule once the Security and Exchange Commission has advised the court of its position on the need for additional discovery. The summary judgment on the fourth affirmative defense, often known as the fair notice defense, in the Security and Exchange Commission against Ripple case is likely to be the one that is most eagerly watched by the public. The Security and Exchange Commission was unsuccessful in its attempt to strike that argument, resulting in a significant victory for Ripple and individual defendants, who also saw the court state its terms, ultimately siding with Ripple on the issue of fair notice. A previous court order by Judge Annalisa Torres identified the following critical factors that may be considered in a future summary judgment on the fair notice defense: whether XRP was sold as an investment or not, and whether Ripple has or does not have any relationship with the vast majority of XRP holders. In response to both allegations, Ripple rejects them both, and the court finds that this may make all the difference in purposes of fair notice. If this is accurate, it would create legal difficulties about whether Ripple had received fair notice that the term investment contract applied to its transfer of XRP, and the court may well be required to address these issues in further depth. What if the Security and Exchange Commission view about XRP is accepted by the court? What do you think will happen to XRP and Ripple? Also, there is another update on the lawsuit. The recent development was announced to the public by the attorney for the defense party, James Phelan, who said that the order was sent by text. As stated in the order, the Commission has exactly 7 days to notify the court of its discovery findings. Ripple will have until April 8 to produce a response to the Commission objections, due to the fact that the whole procedure is now through another review. While this is going on, the decision on the extra evidence will be heard by the court on April 15. Phelan has also said that these timeframes are susceptible to change, depending on how quickly Ripple Labs takes action in response to the information presented. The XRP community has continued to express dissatisfaction with the actions of the regulating body, with some claiming that they are attempting to waste time by doing so. Others feel that when the long-running dispute is finally resolved, Ripple will stand to gain as a result. James Phelan tweeted that, "The Security and Exchange Commission request for an extension of time was granted in a text-only order." It stated, "The Security and Exchange Commission shall inform the court of its position on whether any additional discovery is required within a week of the filing of the individual defendants." So it appears that the individual defendant's answer is due April 8, 2022. The Security and Exchange Commission position on additional discovery is due on April 15, 2022, and the joint proposed scheduling order is due April 22, 2022. The filing of the individual defendant's answer is the triggering event. When the answer is filed, even if before April 8, the date the answer is filed starts the 2-week clock running for the filing of the Security and Exchange Commission position on discovery and the joint proposed scheduling order. The individual defendants have filed their objection. The Security and Exchange Commission has delayed resolution of this case long enough. Nothing should further delay Ripple from moving for summary judgment and demonstrating to the court that XRP is not a security. The court should deny the Security and Exchange Commission motion for yet another extension of time. The XRP community reaction to the post was mixed, with some expressing anger at the Security and Exchange Commission as just trying to gain time in a case already lost, while others such as Twitter user, Cole the Mailman, suggested that the delays could be good for XRP in the long run. This is a good thing. The Security and Exchange Commission will have no excuse as to timelines and more delays after a schedule has been confirmed. Also, they will not be able to say they were rushed when and if it comes down to summary judgment. What do you think? The extension by the Security and Exchange Commission is the same delay tactic used by them again and again? Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video. Kindly note that the prices of cryptocurrencies frequently change, so by the time you watch this video, it might have changed to a whole new value. The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only and hence should not be considered financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions.